Good morning, my lord. Robertson for the pursuer. This is the die of debate on the pursuer's preliminary plea to the principal action. This is the first plea in law, that the defender's averments in answer are irrelevant and lacking in specification. Therefore, the defender's pleas in law should be repelled and decree de plano granted as craved. Being that the defenders admit they are due liquid sums to the pursuers in relation to numerous contracts for the supply of asphalt, where no averments have been made to state that the pursuer has breached those contracts. The defenders now seek to retain payment for those contracts pending the determination of an illiquid counterclaim. However, they cannot relevantly do so given that the sum is in relation to separate contracts. Does your lordship have the record, Rule 22 note and productions in front of him? And has your lordship read the record? Obliged, my lord. At the end of my submission, I will ask your lordship to grant decree for payment to the pursuer for the sum of £36,000. This is the total of all contracts between the pursuers and Prime Macadam Limited that are due, that are liquid and that are not in dispute. I will also ask your lordship to fix a diet for proof to determine the counterclaim before also requesting expenses to date as taxed. Between the 17th of June 2020 and the 28th of November 2020, the pursuer entered into a series of contracts with the defender to supply the defender with asphalt to different sites. The invoices for each order and subsequent delivery can be found in the pursuer's first inventory of productions. Each invoice fell due within 30 payments of issue to the defender. With the exception of 5112 and 5113 of process, there are no disputes over any of the other invoices. The pursuer has not received payment for any of these invoices, which comes to a total of £43,200, the sum which was initially craved for. The defence avers, however, that the asphalt delivered under the last contract was defective and therefore the pursuers were in breach. This is the basis of the defender's counterclaim. It is of note, that the last contract which incurred the alleged breach was for supply to two different sites, Kirkcaldy and Bothwell. On November the 28th, 2020, the defenders ordered 2 batches of asphalt to be delivered on the 29th of November 2020 at the agreed price of £3,600 per batch. The defenders subsequently requested these 2 batches were split between 2 sites, Kirkcaldy and Bothwell. The pursuers delivered the asphalt accordingly to both sites on the 29th of November 2020, concluding that individual contract. The defenders of our breach occurred with the asphalt to Kirkcaldy. The pursuers dispute this. As mentioned, the invoices for both can be found at 5112 and 5113 of process. Each invoice for £3,600 totalling £7,200 for the entire contract. Invoice at 5112 of process is for delivery of the alleged faulty asphalt to Kirkcaldy. It's on this basis that the defenders withhold payment of the full £43,200 for the series of contracts. The defence avers they incurred £95,000 in costs for remedial works resulting from this alleged breach. The defenders aver they are entitled to retain payment of the principal sum pending determination of their counterclaim. The counterclaim seeks these damages of £95,000, and a liquid amount that I submit requires determination at proof. It is my submission that the defenders are entitled to withhold £7,200 for the alleged breach that occurred in the final contract. The defenders have made no averments regarding breach of the other independent contracts. Therefore, decree should be granted for the liquid sums that fall due under the previous completed contracts. This totals £36,000. A review of the legal position as per McBride's The Law of Contract in Scotland at paragraph 2062, where it's made clear that withholding performance is retention, but when done in relation to a debt, there is often scope for confusion with compensation. At paragraph 2064, it's also noted that the purpose of retention is to enforce obligations. In the persuasive case of Purac Limited against Bizac Limited, 2005, Scots Law Times 37. Purac raised an action against Bizac Limited, with which it was in a construction consortium agreement for the construction of a water treatment plant for a third party. Purac sought declarator that Bizac were not entitled to withhold payment or to retain sums received in respect of work carried out by them, and for payment of the sum withheld. The motion was refused as a relevant defence of retention was pled. In paragraph 9 of this case, Lord Drummond Young notes that retention is a defence to a claim for enforcement of a contract and arises where the party seeking enforcement is in material breach of contract. The party who is not in breach may withhold performance of their obligation until the other party performs its obligations. Lord Drummond Young also notes that retention applies to mutual contracts containing interdependent obligations, as also noted by McBride from paragraphs 2062 to 67. Beginning at paragraph 10, Lord Drummond Young goes on to provide a description of the 4 features of retention, the first being that the right only arises when the 2 obligations are interdependent or one another's counterpart. Secondly, that one party must be in material breach. Thirdly, the purpose of retention must be to provide a party with a form of security for performance by the other party. Fourthly, in line with McBride at 2067, retention can apply to building contracts. McBride at paragraph 1436 tells us that damages are illiquid and that there are difficulties in claiming that the amount of damages should be set off against a contractual claim, such as for price. In another persuasive case, Barton Distilling Scotland Limited against Barton Brands Limited, 1993, Scots Law Times 1261, Barton Distilling raised an action for payment against Barton Brands for whisky supplied. The defenders made a counterclaim for an alleged breach of contract by the pursuers. The defenders pled retention pending determination of the counterclaim, and a liquid claim which required to be heard at proof. Lord Ordinary Osborne held that although mutuality can apply to 2 or more separate contracts where the parties are in agreement, there was insufficient averments made to establish mutuality. Decree de plano was granted and a proof was allowed to address the breach and its value. In this case, the defence relied upon 3 exceptions where retention was allowed, these being where an illiquid claim was admitted of instant verification, where the liquid and illiquid claim are part of a mutual contract, and where retention meets the justice or convenience of a particular case. Lord Osborne at paragraph 27 determined instant verification did not apply and a proof was required. It was also submitted by the pursuers that the mutuality exception applied where expressed provision that the obligations from one contract involved those of another, and no such averments had been made. Lord Osborne held in line with this at paragraph 31, whereby he acknowledged that the defence had pled no averments that the principle of mutuality applied, and at best there was a course of dealing. Lord Osborne at paragraph 29 noted that liquid and illiquid claims must arise directly out of the same contract to justify retention. In paragraph 32, Lord Osborne held that he was not justified in exercising equitable discretion given that there was nothing averred to be so persuasive. In the binding case of Inveresk Public Limited Company against Tullis Russell Papermakers Limited, Scotland, 2010, United Kingdom Supreme Court 19, an appeal against a Court of Session decision where the key issue at hand was whether Tullis could retain payment that was due to Inveresk under one contract in respect of Inveresk's alleged breach of another contract that was being determined in commercial court at that time. The Court of Session decision was overruled and it was held by Lord Hope that retention was possible given that the contracts were inextricably linked. Tullis sought to rely on the exception to the rule of retention, whereby a liquid debt can be withheld in respect of an illiquid claim, where the illiquid claim arises directly out of the same contract, as described in paragraph 30. Thus, their case rested on the principle of mutuality, countered by Inveresk, who contended that retention was not available because the obligations did not arise under one contract. Lord Hope found in favour of Tullis, noting that, although separate contracts, the two agreements were part of the same transaction, and so mutuality was inescapable, as he describes at paragraph 38. Even if the contracts were separate, they were so closely interlinked that they should be treated as one for the purposes of retention. This is noted by Lord Roger at paragraph 54. In application to the case in front of us today, it's clear that the confusion between retention and compensation may have been made by the defence, given that retention of the cost of all contracts is sought. Prime McAdam's obligation to pay the pursuers for all contracts not in dispute is not a counterpart to the alleged breach that occurred in the last contract. Prime McAdam's obligation to pay the pursuer for the final contract is a counterpart of the pursuer's obligation to deliver the asphalt to standard. Secondly, the pursuer's alleged breach is in relation to the final contract, and to the extent it is material is to be determined at the proposed proof. Thirdly, while the purpose of retention is to provide security, in the current circumstances, the security claimed by the defenders is in relation to obligations already fulfilled. It is not possible to withhold performance of an obligation against one that has been carried out with no dispute. While retention is applicable to building contracts, it is evident that the defenders' pleas here are irrelevant and should be repelled as just that. Applying the Barton case to the situation at hand, the defender is not entitled to withhold the £36,000 liquid sum in pursuit of the illiquid amount found in their counterclaim. Additionally, there are no averments to the mutuality of the contracts, nor indication of them being intertwined and as one, and as such, retention for the £36,000 cannot be relied upon. The case of Inveresk is of contrast to the case at hand today. The contracts between Hard-Wearing Surfaces and Prime McAdam were a series of independent agreements, completely separate from one another and capable of being fulfilled in solidarity. Their obligations were not reliant upon one another nor the success of one another. They are not counterparts of one another. In summary, the defenders have made no averments as to a single contract being supplied on numerous occasions, and it is clear that the contracts are not counterparts of one another, and therefore, applying the legal propositions I have discussed, retention of an illiquid sum here is not possible. The defence have made no suggestions that the other contracts were breached in any way, and so retention is not a relevant defence to the outstanding sums due, although I submit that it may be a relevant defence to the counterclaim that they seek. Hard-Wearing Surfaces are entitled to payment for all contracts that have been fulfilled with no alleged breach, and I urge the court to make this finding. On this basis, I invite your lordship to uphold the pursuer's first and second pleas in law and to repel the defender's pleas in law. I also invite your lordship to grant payment to the pursuer of £36,000, this being the sum of all completed contracts that are not in dispute. I also then ask your lordship to find the defender liable in expenses as taxed to date, and to fix a proof on the remainder of the principal action and counterclaim. Thank you.